very delighted to be here and to address such a large gathering of about 500 participants. And it really is quite comforting that, as Professor Barwa mentioned, that COVID-19 has really been disastrous for the academic world because they were the first to be closed. But I believe Professor Barwa has converted this tragedy into an opportunity through use of technology, where I am able to connect with around 500 participants and to spread awareness of a very key economic regulation. So I believe this is a very right approach to do the things in the present situation. So now, at the outset, I thank Professor Barwa, NEF Law College, and the organizers, including the management, for envisaging this event on such an issue which is of great contemporary relevance. And as the Northeast will industrialize and as the commercial activities will increase, we will remember that how foresighted we were in our approach in holding this event on economic regulation. So as the businesses will grow, as the industry will grow, the need for compliance with competition law is going to increase, and it will be, I think, right start to take this opportunity so that we can build a very good capacity building for academics and for the industry as well. So with these words, and not without taking much of the time, I would make my presentation. Essentially, I have divided my presentation into two parts. The first part would be more introductory, more basic, where I can, because of the diverse number of participants which are there in this event, so I will keep it very introductory so that everybody can understand the nuances of this law. And once we are through that stage, I will touch upon some key contemporary issues which are to be discussed in today's time. So with that, I would start with the presentation, and I request the host, Professor Hajarika, to allow me to share the screen.
Yes, sir. So can you share it now?
Yes, I can share now, and I will just now. Can you see the presentation now, full screen?
Yes, sir, we definitely can.
All right. So let me give you first an overview of the competition law in India. And in this, let me mention that Competition Act 2002 is not the first competition law in the country. Even before that, we had the Monopolies and Restrictive Trade Practices Act 1969, commonly known as MRTP Act. But I must mention that the MRTP Act was enacted in an era when our economy was closed and all our activities, industrial and business activities, were primarily in the hands of the public sector units. So at that point of time, there was really not much competition either from the domestic participants or from the foreign participants. So essentially, if you remember those days of closed economy, the consumers were worse off, there were no choices, and prices were very high. So if you take any sector of the economy, you take aviation, you take banking, you take any sector, insurance, banking, finance, any sector of the economy, including automobiles, we did not have many choices. Those who were to go through that phase in the life, they would remember when even owning a telephone connection was a very big luxury, and there used to be a long wait to get a landline connection. So that was the era when the services were very limited, and not only services were limited, the prices were prohibitive, and not everybody could own and possess a telephone connection. But then once the economy opened up, the participants, the private participants came in the market, and we can see the magic of competition, whereby now today we have reached our telephony even in every nook and of the country. So this is very important that this competition is taken to every sector of the economy. Similarly, you take the banking sector. Opening a bank account in a public sector bank like SBI was a very Herculean task, because at that time private banks were not there. They had a monopoly. The level of delivery of service was very poor, and even for opening a bank account, you have to give a guarantor. Now, it was indeed very bizarre that you are going to park your money to a bank and you have to give your guarantee for parking your money, and not the bank which will keep your money in trust. So those were the days. Because of the lack of competition, we really had to little choices, and the consumers were worse off. In aviation also, if you remember, the Air India had the monopoly, and at that time, the flying was a very big luxury. Now today, with number of participants, private players and other players, the air travel has become very affordable. So this is the magic of competition, which is working across all sectors of the economy.
Dr. Singh, can you please unmute yourself?
Yes, now, yes.
Yes.
So even in the automobile sector, we had a very limited choice. At that time, we had only the Ambassador and the Padmini 2 models which are available. So the whole point is that the competition can do a magic, and it can bring goods and services to the consumers at a very affordable prices, giving them a wider platform of choices. So in that background, I was mentioning that the MRTP Act was in an era when our economy was closed and there were not really many players so as to regulate competition. So there was no need. So at that time, the focus was how to curb monopolies. And against that, under the new law, the entire purpose of the law is to foster competition than to curb monopolies. So size itself is not a problem. You can acquire size, you can become big, dominant, and size per se are not problems under the new regime, under the Competition Act, unlike the MRTP Act, where the monopoly itself was frowned upon and was discouraged. So that was our first law, 1969. But after the economic reforms ushered in the country in the year 1991, we had our entire approach shifted from controlling or discouraging monopolies to promoting competition. And the Raghavan Committee, which was set up by the Government of India, that in the light of this new law, in the light of this new economic policy which the Government of India is following, it is important that we review the law, and accordingly Raghavan Committee examined the MRTP Act and was of the opinion that in the new economic paradigm, this law has become obsolete and it requires to be overhauled. Accordingly, they gave a report which made the basis of the Competition Act 2002. Now, accordingly, based on the Raghavan Committee report, the Competition Act 2002 was enacted by the Parliament in the year 2002, and it received the assent of the President of India in January 2003. And from that date, it became the new law of the land. But I must mention that this law was only enacted in 2003, but it could be notified in phases. So initially in 2003, when the law was enacted, it was challenged before the Supreme Court on some constitutional grounds which are not very pertinent for our present purposes. And the Supreme Court delivered its ruling, and thereafter the law was amended through Amendment Act of 2007, and the law was finally notified from 20th May 2009. So 20th May 2009 is the date when the substantive provisions relating to Section 3 and 4, that is the provisions dealing with cartels and abuse of dominant position, were notified. 20th May is also celebrated by CCI as its annual day, where a lecture series is organized on this day. So this is a very crucial day in the journey of the new law, 20th May 2009. And the provisions relating to mergers and combinations, they were notified on 1st of June 2011. So effectively, we are now fully functional from 2011. But otherwise, substantively, we are functional from 20th May 2009. So these timelines are very important. So CCI, I would say, is still a young regulator, because 10 years is not a very long time in the history of any regulator. And this is the time for learning and to build capacities to address the challenges which we face in the fast growing economy. I must also mention that these 10 years have been very tumultuous, because in these last many years, there is a change the way the businesses are done. We are moving towards a digital economy, a gig economy, where the entire brick and mortar has shifted to click and order. So in this entire changing business way of doing, the Commission had to calibrate its approach to the new challenges. And that, of course, is a key point of our today's webinar, which I would be mentioning at the fag end of the session. So this 10 years, when the CCI was gearing up to address the market distortions and to correct the market imbalances, the period has been a period of rapid changes. Not only rapid, they have been very substantial and very significant, whereby the very purpose, the way of doing business has undergone a sea change. So this shift from brick and mortar economy to click and order economy has posed various challenges, and how within the existing law, in fact, the Government of India set up a committee, Competition Law Review Committee, that is also one of the recent developments which I would share, to review the law in light of the challenges. So this is very important, and I would be mentioning that aspect at the end of the session. So as of today, I would say this law, which was enacted in 2002, was amended in the year 2007 in light of the Supreme Court ruling, to bring it in alignment with some constitutional challenges which were made in that petition, and a very minor amendment in 2009. And then in 2017, a structural change which I will make at the appellate level. And thereafter, we have really to move towards a new law and a new competition amendment bill, whereby some changes have been proposed, is also I will discuss in brief at the end of the presentation. So before I proceed to take the new law and its mandate, let me very briefly give some background of the difference between the new law and the previous law, because in this academic setting, it would be very important for the students and the faculty to imbibe this difference between the new law and the old law. As I mentioned, the new law is based on a liberalized economy where there are a number of participants, and we have to really address the market distortions in a different way. The MRTP was based in a command and control regime where the economy was closed and there were few choices. Then the second is the competition concepts have been clearly defined in the Competition Act. So for economic analysis, what are the factors to determine appreciable adverse effect on competition? They have been very comprehensively addressed in the new law. And these were not defined in the MRTP Act, which essentially defined only unfair trade practices, restrictive trade practices, and monopolistic trade practices. So they have not defined these concepts, but only the competition law has defined the very competition terms and the framework for economic analysis to determine appreciable adverse effect on competition. So unlike MRTP, which only defined RTPs, UTPs, MTPs, the Competition Act has provided clarity, and a clarity in law goes a long way in a robust enforcement, because otherwise, if the concepts are not crystallized into statutory definitions, and they remain open-ended, subject to subjective satisfaction and interpretation of the courts and the tribunals and the regulatory bodies. That creates uncertainty in the entire regime. So to that extent, this is also a very major, I can say, improvement in the new law on the existing law. Then I must mention that a very important framework in the new Competition Act is the provision for regulation of combinations. The term used has been combination, that essentially refers to mergers and acquisitions. So beyond thresholds, the mergers which are beyond a particular threshold as defined in the Act in terms of assets and turnover, that is provided. They have to be mandatorily notified to the Commission, and only after the approval of the Commission they can consummate. No such provision was to be found in the previous MRTP. So mergers and acquisitions today, they require mandatory prior approval and notification to the Commission, and only after analyzing the proposed mergers, which essentially in terms of the thresholds, they are very big ticket mergers and acquisitions, only they need to be notified to the Commission. And Commission, after analyzing the proposed merger and acquisition, either accords or refuses to accord or grants permission with certain caveats. So this is a very important provision, particularly in the digital economy, where lots of mergers and acquisitions are taking place. And it becomes very imperative that we do not end up in a scenario where there is a lesser competition or there is a lessening of competition. So that is a very important role which the Commission has been interested to. And India is one of the very few jurisdictions in the world where there is a mandatory requirement of notifying combinations to the competition regulator to assess them ex ante, because this is a very important area which I will address. Then the Competition Act explicitly provides for advocacy, that is to spread awareness, to build capacities, and to provide proactively opinions and reviews of the policies, legislations, so that the anti-competitive effect of policies, legislations can also be reduced at the ex ante level. No such power was available with the MRTP Act. Then statutory authorities can also seek CCI's opinion. And similarly, no such provisions were to be provided under the MRTP Act. And lastly, I would mention that Competition Act 2002, now it is such an important legislation that in section 32, it provides extraterritorial jurisdiction of the Commission. So under the MRTP Act, this was a very major dispute because it did not provide for an extraterritorial jurisdiction. Now,
Dr. Singh? Good afternoon, sir. Dr. Singh, sir. May I request everyone to please kindly be patient. I will just call up our resource person and get back to you shortly.
Cartels operate at global level.
Dr. Singh? Respected participants, apologies for the disturbances, but as you all know, network connections are always an issue. I will call our resource person and inform him that there is a problem. Please be patient with us. Thank you.
Am I audible now?
Yes.
And the presentation can be seen?
Sir?
Yes.
Dr. Singh,
yes.
Sir, could you please share your presentation again?
Okay, I will do that. Now,
yes.
Is it
yes,
visible?
sir.
All right.
Yes, sir.
Okay, no problem. So now coming to the objectives of the Act, the Competition Act was enacted primarily with the objectives to prevent practices which are having adverse effect on competition, to promote and sustain competition in markets, and to protect the interest of consumers, and to ensure freedom of trade. So you can see the objectives of the Competition Act are very many and very different. So there are different constituencies which the Commission has to balance while applying and enforcing this law. Of course, consumer interest is one of a key objective of the Act, but at the same time, the focus is that the competitive process is maintained in the markets. So all these four objectives have to be, attained by the Commission in its enforcement process so that they can be effectively achieved. Now coming to the what are the functions of the Commission? Now primarily I would say that they can be bifurcated in three main functions. Our key task is the enforcement functions that relates to sections 3, 4, 5 and 6. Section 3 deals with prohibition of anti-competitive agreements, and these agreements include horizontal and vertical agreements. So essentially in horizontal agreements we call them as cartels. So this is the key provision, enforcement provision and priority of the Commission, where the cartels are penalized. The second is abuse of dominant position. So this is with respect to the entities which are dominant, very big in their relevant market, and their conduct is examined under the framework of section 4. And 5 and 6 deal with regulation of combinations. So these are the provisions where the mergers and acquisitions are notified to the Commission beyond a particular threshold, and they are assessed by the Commission ex ante to assess whether they are having anti-competitive effect in the market or not. The second function I would say is an advisory function, and under this advisory function the Commission advocates very proactively with its outreach activities with academia, with industry, with the governments, both central and the state governments, so as to spread not only the awareness and capacity of the competition law, but also to review various legislations, policies, so that the government can be provided the inputs in framing and reviewing the policies in an appropriate manner which are competition law compliant. And of course, advisory function is also a subset of the advocacy function, so whereby the governments can seek advice of the Commission on various policies, and they can take that into consideration in formulating the policies. Now, who can approach and how the CCI's machinery or the new Act can be moved? In this, I can only say that proceedings before the Commission are inquisitorial. They are not adversarial proceedings, unlike the courts. Now, our courts follow the adversarial system, Anglo-Saxon adversarial system, whereby there are two adversaries who are asserting their right and they are competing with each other. Now, this is the traditional adversarial system. This is followed in common law countries, there is no doubt about it. But the civil law system or the continental law system of inquisitorial system, as I may say, is the process which is followed under the Competition Act. Because Competition Act does not address an individual concerns. The competition law redresses market distortions. It corrects market distortions. So any member of the public can approach the Commission, but ultimately the relief and the remedy which would be provided would be to correct the market distortion as a whole. So therefore, the proceedings before the Commission are in rem, they are inquisitorial, they are not adversarial, and therefore the Parliament provided that any person or consumer or their association or trade association can approach the Commission. So it is not necessary that only an aggrieved person can approach the Commission to move the machinery of the Competition Act into motion. In this, I would mention
Dr.
Yes. So in this, I would mention that though there are certain judgments which have come from the Appellate Tribunal about the locus standi of the person who can approach the Commission, and thereby certain caveats have been entered by the Appellate Tribunal that the person should have some direct effect. He should be either a competitor or an aggrieved consumer. But if you see the scheme and approach of the Competition Act and the various other rulings delivered by the tribunal itself, and the legislative scheme, then it is abundantly clear that any person can approach the commission to move the machinery into motion. At the same time, the governments, the state governments and the statutory authorities, they can also make a reference to the commission. Particularly, they make reference in case of bid rigging, which is a cartel by the bidders in various public procurement activities. And of course, a very key power which has been given to the commission is that commission can initiate suo motu proceedings based on any information which can be received by it through any source. So this is a very important and necessary provision, particularly for a market regulator, because it need not be reactive in its approach in correcting market distortions. So for that purpose, this suo motu power is conferred upon the commission to address the market distortions which are taking place. And in case of mergers and acquisitions, that is the combinations, there is a mandatory requirement of notification by the merging or acquiring entities to notify to the commission and to obtain the approval of the commission before such combination can be consummated. Then I must again elaborate now these enforcement functions specifically. Now this is a very key area for the students, faculty to appreciate that what are the enforcement priorities. Now, prohibition of anti-competitive agreements. Now, anti-competitive agreement essentially are the agreements which are captured under the framework of the competition law if they cause appreciable adverse effect on competition. Very broadly, I would say the anti-competitive agreements captured under the law are of two types. One, and very colloquially I am saying, are the horizontal agreements. That is the agreements amongst the competitors, like cement companies. If they all join hand together and through an understanding and an agreement, if they enter into and decide to raise price or to otherwise limit supplies. So this type of arrangements is captured under section 3. Then we have vertical agreements. That is the agreements which are between the producer and the wholesaler, or between the wholesaler and the retailer. Now, vertical agreement is between the entities which are at different levels in the production chain. So as you would see that horizontal agreements, unlike vertical agreements, are the agreements between people who are directly competing, and therefore they are being viewed very seriously, because it would be very axiomatic. Why two competitors are meeting? After all, competitors have to compete in the marketplace. So therefore, as the great economist also said, Adam Smith, that when the two competitors are meeting, they are not meeting to discuss whether, but they are meeting to fix prices. So therefore, the Competition Act views such horizontal agreements more seriously, and accordingly, they are presumed to have appreciable adverse effect on competition. So there is a statutory presumption of appreciable adverse effect on competition arising out of horizontal agreements, which I can broadly say are cartels. So cartels are considered to be very pernicious, very extreme form of anti-competitive behavior, and across the jurisdictions, such behavior is viewed very seriously by the law and by the competition agencies. And even the law provides for very aggravated penalty for cartels. So cartels essentially are the agreements amongst the competitors to fix prices, limit supplies, or otherwise to do the anti-competitive behavior. And they are viewed very seriously, so much so that the regulator does not even have to demonstrate appreciable adverse effect on competition due to cartel conduct. It is presumed by virtue of a statutory presumption of appreciable adverse effect on competition. And of course, I would say, and I must add, that commission can, this presumption can be rebutted by the parties through appropriate evidence if they have any. Now coming to the vertical arrangements. Now vertical arrangements are the agreements between the producer and the wholesaler, or between wholesaler and the retailer. Now these types of arrangements, they are viewed differently, slightly differently from the horizontal agreements. In that this presumption of appreciable adverse effect on competition is not applicable in respect of such behavior. So here the Director General, the investigating arm of the Commission, and the Commission itself, they have to demonstrate the appreciable adverse effect on competition arising out of such agreements between these two players who are at the vertical level. For example, the tie-in arrangements. If you remember the MRTP times, the vertical arrangements we had in a context when we used to take an LPG connection, then the service provider, while giving you connection, he would also insist you to take the gas stove with you. So that is a typical tie-in arrangement when you are forced to purchase another good for purchasing the good which you have gone to the service provider. So that type of behavior, tying in exclusive distribution, exclusive dealing, this type of behavior by way of vertical restraints is captured under section 3 subsection 4 of the Competition Act. And as I mentioned, that unlike cartel, this type of behavior in appropriate cases may also have some efficiency or redeeming feature, and therefore the law treats vertical arrangements with a different approach than the approach which is adopted to address the cartels. So here the Parliament has said that the regulator has to establish that the anti-competitive agreement, the vertical anti-competitive agreement has caused appreciable adverse effect on competition. This has to be established by the Commission and not otherwise. So this is very important distinction for the students, faculty, and the practitioners of law to understand that the key difference is that vertical arrangements, they need to be dealt with differently, unlike the horizontal agreements, cartels. Then there is a key provision, section 4, which prohibits abuse of dominant position by the enterprises. Now, this is a very important provision of law. Unlike section 3, which talks about anti-competitive agreements, and whenever we talk about agreements, we envisage and conceive minimum 2 players. But in abuse of dominant position, it is a unilateral contact. So this is again a very key distinction which the students and the faculty may keep in mind, that unlike agreements which would necessarily require minimum of 2 parties, in section 4 cases, there will be only one party. That is the abuse of dominant position. That is a party which is having considerable market power in the relevant market and which is abusing that market power in an exclusionary or in an exploitative manner to the detriment of all. So that is the abuse of dominant position provision in section 4 of the Act. Then we have the combinations, that is the mergers and acquisitions. Now, mergers and acquisitions taking place in the economy through the inorganic route of growth, they are to be notified to the Commission for their approval if they are beyond a particular threshold. Now, it is very important that these transactions are processed at the earliest. There is a statutory limit of 210 days. So the Commission has the time limit of 210 days to process these combinations or these merger notifications. Otherwise, they are deemed to be approved. So this is a very key provision, and I am happy to report that as against the 210 days statutorily given to the Commission has been processing these cases at a much faster rate. That is around 30 to 35 days on an average they are being processed. And in fact, recently the Commission has come out with a green channel route whereby they are, the moment they are filed before the Commission, they are deemed to be approved for certain categories of transaction. So this is just an elaboration of the anti-competitive agreements of 2 types, that is the horizontal and the vertical. So in the horizontal, you would see cartels, bid rigging, they fall. Now, government also is a very big procurer. Whenever they float a tender, bidders participate, and while participating in the tenders, they invariably or sometimes they collude with each other to rig the tender and they decide beforehand how much price to be quoted. So that defeats the very purpose of tendering process, competitive tendering process by such behavior of the bidders. And public procurement is very important. It constitutes about 30% of our GDP, and any anti-competitive behavior will deny the government or the procurer the value for money. So these cases are very important, and they are routinely reported by the state government, central government. In case procurement they detect or suspect any cartel by and amongst the bidders, then such conduct is immediately reported to the Competition Commission of India, and that is being investigated by the Commission as per the statutory scheme. So bid rigging is a type of cartel. It is in the context of specific behavior, specific tendering process that this behavior takes place. Then there may be some common practices also, if they are done in concert, that can also be captured under this. Lastly, it is the vertical agreements which I mentioned. It is not between competitors, but it is between the two people who are at different stage in the value chain. So exclusive supply or distribution agreement between the producer and the wholesaler, tie-in arrangements, and refusal to deal. I will elaborate them. Now, coming to the second enforcement mandate, that is the abuse of dominant position. I must mention that unlike the MRTP Act, now this is very important, that so this is a key provision, unilateral conduct of a big enterprise. So in the previous MRTP law, the size itself was a problem. The focus was on curbing monopolies. So big companies were not allowed to grow because that was considered to be against the economic policies at that time. But now, if the focus is that companies can be big, the size is not a problem, because that also gives them benefits of scales of economies, and that ultimately may help consumer welfare also. But if the dominance or that size or market power is abused, then only it is prohibited under the new law. So as we say, dominance per se is not bad, only abuse of dominant position is bad. So this is a very key learning and a paradigm change under the new statute from the previous law. And therefore, we have to be very clear that while looking at the cases of abuse of dominant position, firstly we have to define the relevant market. What is the market in which we are examining the conduct? That relevant market is defined in terms of the relevant geographic market and the relevant product market. Once we define the relevant market, then we decide whether the entity is dominant or not. Dominant means having the market power, having the monopolistic power, or close to monopolistic power. There may be number of players or maybe some players, but ultimate test is, and there are various factors, market share alone is not the decisive factor. If there is no prohibition in entry and the entry is easy, then notwithstanding high market share, the entity may not be dominant. So the whole test is, what are the market constraints? So these concepts are given, as I mentioned in the beginning, in the competition law in a very comprehensive manner. So Commission can analyze whether a given entity is commanding a market power or not. Then the third stage is to determine whether that entity is abusing its dominant position or not. There are two types of abuse mainly. One is the exploitative conduct that directly affects the end consumers, and the other is the exclusionary conduct. That conduct affects the other competitors in the market. So this abuse of dominant position is very critical for us to understand. One, it is of two types, exploitative and exclusionary. And unlike some other jurisdictions which don't look at the exploitative behavior, our law also looks at the exploitative behavior, which is direct concern to an end consumer. Let me give an example. One case which we decided was this DLF, the DLF case. In DLF case, the DLF, a real estate major in NCR region, near and around Delhi, it was found to be dominant in the relevant market of Gurgaon, in the high-end apartments. And there were various terms and conditions of the flat wire agreement which were one-sided, unfair, and heavily loaded against the buyer and in favor of the builder. Now, Commission found DLF to be guilty of abuse of dominant position in the relevant market due to insertion of these terms and conditions, and imposed a penalty of rupees 600 and around 30 crores. So this is a very big deterrent for anti-competitive behavior. So that penalty was imposed, and this conduct was exploitative conduct because it directly affected the end consumer. But at the same time, a dominant undertaking can behave in a manner so as to result in foreclosure of market for other competitors and market participants. That type of behavior is known as exclusionary behavior. So there are three abuses, which are, first abuses are exploitative nature, and then there are exclusionary nature. So our law is very wide in its sweep. It addresses the concern of the consumers. It also addresses the concern of the competitors. So that is very important, that this our law is having the last mover advantage, and in that sense it is based on the best global practices in the world, and it is, our law is very comprehensive in its sweep. Now let me mention, as I said, the combinations. In the combinations, the mergers and amalgamations and acquisition, they all are covered under this definition, and the combination taking beyond high thresholds in terms of assets and turnover, which are defined in the law and which are periodically revised, taking into consideration the inflation and the other changes in the economy, they are revised. And based on that, the merging entities, acquiring or amalgamating entities, they need to notify to the Commission about their this act, and only Commission's approval they can consummate or complete the process. Now I must mention that there is a mandatory pre-notification requirement. In some jurisdictions it is voluntary, but in our jurisdiction they have to mandatorily and compulsorily required to notify, failing which penal action can be taken by the Commission under the Competition Act. Then, as I mentioned previously, the Commission has been given a time of 10 days to process these things, otherwise they are deemed to be approved. Now, coming to the advisory functions, as I mentioned, the central government or the provincial governments in formulating policy, they may seek the opinion of the Commission, and the Commission can provide its opinion, so that Commission can say whether a particular policy is going to have any anti-competitive impact in the market or not. So this is a very key provision, because many anti-competitive behavior may also arise due to government policies and due to the government policies and the legislation. So this requires a competition audit. So what the Commission does, the Commission actually reviews the law from the competition law perspective and advises the government that these provisions need to be reviewed, because either they are hindering competition in the market or they are creating an intense monopoly in the market. So this is a very important area for the Commission, and whereby we are advising the government. And as you would appreciate, if the policy itself is competition law compliant, then it will definitely reduce enforcement task. So this review, the competition audit, takes place at ex ante level, and when actual conduct takes place, then ex post facto level through enforcement priorities, we impose and penalties for this behavior. So Commission uses its advocacy functions at ex ante level by reviewing laws, policies, bylaws, and other executive instruments to assess whether they are competition law compliant or not. And Commission is doing very proactive measures in this direction by engaging with the appropriate branches of the government at the ex ante level. But nonetheless, at ex post facto level also, we have a statutory mandate through enforcement mandate. We also examine and penalize such behavior if that is found to be violating the law. Then, of course, advisory, as I mentioned, unlike enforcement, is only a persuasive task. We can only advise the government. It is ultimately for the government of the day to take the opinion into consideration in the overarching their own priorities and to amend the law and the legislations. Now, of course, other than advisory, we have also been explicitly, and this is one of a very few law where explicitly advocacy functions have been provided in the Competition Act itself. And CCI has been mandated to promote competition advocacy, to create public awareness, to impart training about competition issues. And I may say so that today my participation in the webinar is also as a part of the statutory duty of the Competition Commission of India to take advocacy functions. So in this process, this is an advocacy event also for the Commission as a part of its statutory mandate to spread awareness of the law amongst the stakeholders. Then I must say, this is very crucial, that what are the powers of the Commission. Now, if you see ultimately the effectiveness of any law or the regulator will depend upon what types of powers it possesses and how it can enforce that thing, so that it can really create a culture of compliance, particularly culture of competition compliance in our context. Here I must say that first and foremost thing for any regulator, particularly the competition regulator, is to ask the entities to stop such behavior and to desist from indulging in such behavior in future. That is the cease and desist part. That is the order is in RAM. So it is not necessarily between two parties which have come before the Commission. Now, MRTP Commission had this power only, cease and desist power. They did not have any other power of imposing monetary penalty. So that is why one of the key drawback of the MRTP Commission was that it was lacking teeth. It could issue cease and desist order and it could not impose any monetary penalty. So that was also one of the key criticism of the previous regime. I am happy to say that under the Competition Act, the Commission has the power to impose a monetary penalty which can go up to 10% of the average turnover for the last 3 preceding financial years. And this turnover is taken into account to impose a monetary penalty upon the enterprises which have violated the law. You can gauge the enormity of this power that in the cement cartel case, Commission imposed a penalty of 6,300 crores upon 10 cement companies. Now, this is a very big penalty imposed by any regulator in India. So this flows from this provision only. It can go up to 10% of the average turnover of the last 3 preceding financial years. And of course, in the case of cartels, it can go even up to 10% of turnover or 3 times of the profit, whichever is higher. So in case of cartels, there is an additional aggravated penalty which the Commission may also impose if considered appropriate. So this creates a very sufficient deterrence. So of course, the market correction is the ultimate goal and imposing penalty is not the task or the objective of the law. This is only to create deterrence and to desist the parties from indulging in anti-competitive behavior. But at the same time, I must say that mere advocacy, mere cease and desist, unless they have some economic impact for the entities for such behavior alone is not sufficient to imbibe or to impart a culture of compliance. So we have to use our all remedies and powers very judiciously so that there is a healthy mix. And through a nudge and wherever it is necessary to use the harsh route, we can discipline the behavior of the market participants to bring that in compliance and in alignment with the objectives of the Competition Act. Then, of course, in very important power, the Commission has been given the power to declare the agreements void if they are causing AAEC, that is the appreciable adverse effect on competition. Now, this is a very critical thing. Now, Commission has been given this power and to enter into the contractual thicket. So, Commission can enter into the contract, examine it, and if the contract imposes unfair or discriminatory terms and conditions, then not only it can declare them inoperable, it can declare them void also. So, this is a very important power. Normally, in any economy, there is a sanctity of contract and it is a document executed by and between the parties. And civil courts, of course, can declare such contracts void on very well-defined narrow grounds of public policy. But CCI has been given this overarching power to even modify the agreements and to declare the even agreements as void if they cause appreciable adverse effect on competition. So this is the framework in which you would appreciate that Commission can be has been given a very wide mandate, very big powers, whereby they can even modify the agreements and they can even declare the agreements as void if they are anti-competitive and they cause appreciable adverse effect on competition. Let me also mention that not only this, the Commission has the power to even divide and forget about contract. Even the enterprise itself can be sliced and diced. If an entity becomes too big, then under Section 28, it can be divided into smaller enterprises. Now, this is a very, this is known as the nuclear button of the Competition Act, Section 28, whereby Commission can even divide the enterprise. It is a very drastic remedy, structural remedy. Unlike cease and desist and penalty, which are behavioral remedies, this is a structural remedy, and I can say that so far the Commission has not invoked this drastic power under Section 28 in any of the cases, because as I mentioned, these are the early times. Economy is also in the sea of change, how in the new e-commerce we are moving. So this drastic power so far has not been, and the market participants are given sufficient time to understand the new law and to bring their behavior in sync and in compliance with their mandate. Otherwise, of course, the Commission retains this power to be exercised in an appropriate case. Commission can also issue interim orders if the anti-competitive behavior is of such a nature that it requires immediate cessation. Then in the appropriate case, the Commission can also order, issue interim directions and can stay such behavior. And of course, in mergers and acquisitions, the Commission can either approve them or can approve with modification, or it can even refuse approval. And I can report to you that so far the Commission has approved the mergers in a very fairly reasonable period of 30 days around, as against the 210 days statutory period available to the Commission. And no merger has been so far refused approval. At the best, we have cleared various mergers with appropriate modifications. Now, let me also mention very briefly that how the process moves before I come to some pertinent issues affecting and which are of some relevance. That CCI's orders, CCI being a quasi-judicial sort of body, adjudicatory powers are there. So these rulings are appealable before the National Company Law Appellate Tribunal. As I mentioned in the beginning, that Competition Act was amended through Finance Act in the year 2017, whereby this power has been given to the NCLAT to hear the appeals against the orders of the Commission. Before that, we had a dedicated tribunal, Competition Appellate Tribunal, popularly that was known as COMPAT. So COMPAT had that power, and whereby the appeals against the CCI's orders can be heard and disposed of. But in 2017, the government merged COMPAT as a part of its policy of maximum governance and minimum government. So they merged these tribunals, and now the NCLAT is hearing the appeals against CCI simultaneously along with the appeals against NCLTs. So NCLAT hears appeals out of NCLT orders under the Companies Act, and this is the same body which has also been designated to hear appeals against the orders of the CCI. So, and then a further statutory appeal is provided to the Supreme Court. So finally, I must mention that this is a three-tiered approach, whereby the orders of the CCI are first appealable before the NCLAT, and then at the second level, they are appealable before the Supreme Court. Now, I must mention that jurisdiction of courts, civil courts has been excluded, and only CCI, being an expert regulator, can look into such conduct, and the private party, the courts cannot look into them. Of course, the judicial review of the High Courts and Supreme Court remains intact. Coming now to the last part of my presentation, I must mention that what are the key recent developments which are taking place in the competition law field. I must mention that at the policy level, at the government level, at the statutory level, the government set up a competition law review committee report, and that committee report, which has come last year, now it has provided certain changes in the law, which are in line with the difficulties faced and the experience gained in the last about 10 years of enforcement. So this committee has recommended that there should be a provision for settlement and commitments. That is, the anti-competitive behavior must be allowed to be settled and committed through the voluntary actions of the parties instead of commission imposing penalties. So if the companies come forward for a settlement or a commitment, then without ordering a lengthy inquiry, the matter can be decided. So this is a very far-reaching change, and it is globally also available in the statutes. And then the second recommendation was for green channel notifications. If during, say, bankruptcy, some companies are being acquired by other companies, then these mergers should not take undue time. In fact, Commission has already put in place green channel mechanism whereby certain categories of combinations are deemed to be approved the moment they are filed before the Commission. A very important thing is hub and spoke cartel. Now, as I mentioned, presently we have only horizontal arrangements or vertical, but there may be a hub and spoke arrangement also, whereby, for example, a OEM or a manufacturer of, say, automobile company, he is monitoring the discount given by the dealers. So dealers operate at the spoke level, and the hub is the OEM, the manufacturer itself, which is at the vertical relationship. So he is not captured in the traditional cartel. So this type of arrangements, which are also under the existing scheme, also can be captured, but they are explicitly sought to be captured under the new recommendation and the new law based on this recommendation. Then I will come to the other points, deal value thresholds. In the context of, you would see that now this is an era where, we are talking about big data, e-commerce, algorithmic collusion, artificial intelligence, blockchain technology. Now in this era, there are various mergers which take place, and the acquiring entity, now for example, Facebook, WhatsApp deal, which Facebook acquired WhatsApp. Now WhatsApp doesn't charge any subscription. It does not have any advertisements. Its revenue was practically nil. But when the Facebook acquired, they paid a very big sum, I guess around 25 billion US. So how did they acquire such a power when their revenue was nil? So that is the data, the big data, because this data is very critical in our today's economy, because it helps businesses in targeting consumers and to develop new business models as per their needs and behavior. So that is one very important aspect, and big data. So deal value thresholds are very important, because in digital markets, if you are going to acquire a company, their assets may be very light, their turnover may be negligible or zero, but then they have a huge value because of the data. So that is not captured presently, and such deals fall through the radar of the Commission. So the CLRC has proposed that Commission should be given power to review such deals also, which otherwise cannot be notified due to assets and turnover requirements as are presently provided. I must lastly mention that realizing the role of e-commerce in the economy, the Commission commissioned a study, market study on e-commerce in India, and it examined these various platform businesses, and to understand the functioning of e-commerce in India and their implications on the market and the competition. The main objective of the study was to understand the industry more closely, so as to effective enforcement and advocacy priorities that learning can be I think suitably used. And I must mention that the key areas of the study where the Commission required was that platform neutrality. The platform should not discriminate whether it is a e-tailer or whether it is a transport like Ola, Uber, Amazon, Quicker, whatever platform it is there, the platform neutrality is really a key. So is the price parity clauses and the exclusive agreements, which are often found in some cases. Deep discounts, of course, is a very important area. So the platform should remain neutral so that everybody is provided access in a non-discriminatory manner on these platforms. So this report, while recognizing the competition-related issues in the e-commerce market, suggested measures for ensuring free market to avoid market distortions, which include increased transparency in parameters of search. There should be no search bias when we search either on Amazon, Flipkart, or anything, any platform business. So the search bias this is a very important area, that there should be absolutely search should be organic search, and it should not be manipulated, and platform should remain neutral and maintain parity for those who want to sell their products on the platform. So with this, I conclude my presentation part, and now I request Professor Hajarika to coordinate on the questions and answers.
Thank you, sir. Definitely. Thank you, sir, for making an excellent presentation and gracing this webinar with your exemplary insight. Thank you for such an informative presentation and making it a learning experience for us all. Now, I would like to hand over to my co-host, Mrs. Joyita Rajkhwa, to hold the interactive session.
Hello. Hello, can you hear me?
Yes, yes, please.
A very good afternoon to one and all present here. First of all, I'm very much honored to be a part of this national webinar among such dignified dignitaries. But without taking much of your time, I would now like to start with the interactive session. We have some participants from outside the state, so I would first like to highlight the questions put forth by them. First, I would like to request Mr. Kaushik Chaudhary, who is an advocate on record Supreme Court of India, to please come forward and put forth his question to the resource person. Mr. Kaushik Chaudhary, can you hear me?
Yes, yes, Mrs. Joyita. Thank you. I hope I am audible and visible to all.
Yes, sir, you are.
Thank you, sir, for such a wonderful speech. In fact, it is very valuable from your part and for giving us such a precious time of yours. And thank you, NEF Law College, also for giving us the opportunity to be there with everyone. Sir, as a question is to be asked from my side, as put by Mrs. Joyita. So I was, as sir has mentioned about Ola and Uber at the end of this webinar, I was thinking how Ola and Uber, even after showing so much of dominance and reducing the price to, in fact, destroy all the competitors in the market, how they have overcome the Competition Commission Act. Means at any point of time, we have seen that Ola Uber has never been questioned by the Act, whereas they have, in fact, created a complete incompetence of the other transport services. For example, Meru and other who have been asking for a very high amount. So in that, if I may have give us some.
Yes. So firstly, I must say that whenever a new business model comes into picture, the old business undergoes a change. Now we have to see the consumer welfare also in our mind. Now, I am not on any specific Ola, Uber or Meru other comparison, but I must mention that there used to be a time when hiring a taxi itself was a very big challenge. Now today through technology, the riders are connected with the drivers. So with an ease of an app, we can immediately connect with a taxi which is nearby. Unlike the traditional taxi market where you have to call and they already charge you 10 kilometers from garage to home and vice versa. So that is one aspect, that how it transforms the business. Of course, in this process, there will be some who will lose and some will gain, and a new participants would come. So that is one aspect which we have to bear in mind. As far as the statutory framework is concerned, as I mentioned, that if an entity is dominant in the market, then commission can look at it. But see the market. If there are two big players like Ola, Uber or Amazon, Flipkart, now we have found that in such a market scenario, can we say that one entity is independently work of the other forces? So that is a question we have to decide. Our competition law presently does not have a concept of joint dominance. In fact, this issue also came up before the Competition Law Review Committee. You are entirely right. If these type of two entities, but no entity can be said to be dominant in a market structure when two entities are equal almost. So you cannot say this is dominant and this is not dominant. So we can only capture, there can be only one dominant in a market. So if there is only one entity dominant and there are two strong competitors competing with each other, it is very difficult to hold in such a market construct that any body of them is dominant. Be that as it may, Supreme Court has ordered investigation. and that matter is pending. So I don't believe that Commission has not looked into that or is not looking into that, but the matter is pending, and even the Supreme Court has said that investigation should take place, and then we can be able to say that what exactly was the behavior which we must address.
Thank you, sir. Thank you for enlightening us.
Thank you, Kaushik sir, for your wonderful question. Now I would like to invite Mr. Rangan Chaudhary, who is currently working as the Assistant Attorney with the Kachwaha and Partners, New Delhi, to put forth his question to the resource person. Sir, can you hear me?
Hi, am I audible?
Yes, sir, you are audible.
Good afternoon, Mr. Singh. It was an absolute pleasure hearing your thoughts on competition law. My question is going to be slightly different compared to what was spoken today. I was hoping to understand a little bit what exactly do you think is going to be the impact of COVID-19 on the enforcement regime insofar as competition law is concerned, specifically in relation to the fact that the CCI, in my knowledge at least, has not issued any specific guidelines insofar as limited cooperation between competitors is concerned, like the EU or Canada. So how do you think is the current regime going to impact the antitrust enforcement in India?
Thank you very much for this question, because this is very important, particularly in the COVID times, that what actions, what advisory, what guidelines Commission has issued. And Professor Barua was right in the beginning mentioned COVID. So I also wanted to address this issue, but due to the limited time, I could not speak, but you have made it good by raising this issue. I must say, firstly, as you mentioned, the Commission has issued an advisory. Now,
right.
So the scope of the advisory, I must say that our Competition Act is very robust. It is very modern law. It has the foresight of inbuilt provisions are there that if during times of crisis, the parties are collaborating for enhancing efficiency, now that has been already addressed by the law. So what the Commission has done, what the Commission could have done within the existing architecture, because law cannot be altered, and I do not believe it requires any change to address COVID at all. Now, we have pointed out about this collaborative arrangement. So as I mentioned, that cartels we frown upon, they are considered to be very pernicious. But in COVID times, for example, if there are two manufacturers of N95 mask and one says that I am dealing with the northern territory, you take care of the southern territory so that we can utilize our capacities effectively. Now that type of limited collaboration under the inbuilt provisions of the Competition Act is addressed sufficiently. So I guess the Commission could have only pointed it out very clearly so that it inspires more confidence among us the businesses that this type of joint collaboration would not be viewed as a cartel but as an efficiency enhancing measure, and it would not fall foul of the law. I think that was the whole purpose. But if I believe your question was that more detailed guidelines, I believe that may not be required because it is ultimately a case-to-case analysis. And if any particular sector of the industry requires to be exempted due to COVID, I think that call has to be taken by the central government under Section 54 of the Act. Thank you.
Thank you. Thank you so much, sir.
Thank you, sir, for your wonderful question. Now, I would like to invite Mr. Manish Kumar Das, Advocate, Guwahati High Court, to put forth his question to our resource person. Sir, are you there? Can you hear me? Hello? Mr. Manish Kumar Das?
Yeah, hello. Good afternoon. Can you hear me?
Yes, I can hear you, sir.
Okay, thank you so much. First of all, I'd like to thank Sir for this valuable